The pension check bounced on a Monday morning in October, and Virginia Hale stood at the kitchen counter, holding the bank's automated message on a slip of paper, and tried to understand what it meant. She had received that pension check every month for 11 years without interruption. The account it was deposited into had held, as recently as the previous spring, just under $340,000. A man named David Solis had been managing her finances for 4 years, since the month after her husband died, and he had been in every visible way exactly what he presented himself to be: attentive, capable, and reassuring in the specific way that people who are stealing from you learn to be reassuring. What nobody knew was that beneath the floorboards in the master bedroom, under the section of oak planking her husband had loose laid over a crawl space access, in 1987, there was a fireproof safe that Thomas Hale had put there himself and told no one about except Virginia, and told Virginia about only once, and only because he had said, "If I'm ever gone and something goes wrong with the money, start there." In 2021, in Los Angeles County, California, a 76-year-old widow lost $2.2 million in savings and real estate over 4 years to a man who had positioned himself as her trusted financial advisor following her husband's death. This is her story, with details changed to protect her privacy. Virginia Hale had lived in the house on Cordova Street in Pasadena since 1979. She and her husband Thomas had bought it young. She was 32, he was 34, with a down payment assembled from 3 years of careful saving and a loan from Thomas's father that they had repaid within 5 years because Thomas was particular about debts. It was a 1940s California bungalow with original hardwood floors, a detached garage, and a lemon tree in the back corner of the yard that produced more fruit than they could use, and which Virginia distributed to neighbors every July in paper bags with her name written on the side. Thomas had been a structural engineer. Virginia had worked as an office manager for a medical practice in Arcadia for 22 years before retiring in 2010. They had no children. They had each other. And then they had the careful architecture of a life built for two that continued after one of them was gone. Thomas died in February of 2017 after a short illness at 72. He had managed their finances with the same systematic attention he brought to his engineering work. Detailed records, conservative investments, no debt, and a portfolio that by the time he died included the Cordova Street House, 2 small rental properties in Glendale, and a combined investment and savings position of approximately $1.4 million. He had not left Virginia without resources. He had left her without the knowledge of how to manage them, which was a different problem, and one he had understood was coming and had tried, imperfectly, to address. David Solis introduced himself at a community seminar on financial planning for widows held at a Pasadena library branch in April of 2017, 6 weeks after Thomas's funeral. He was 51, well-dressed, and spoke with the fluency of someone who had explained compounding interest and estate management to grieving people many times before. He had a registered investment advisor credential, a website, and a suite of offices in a professional building on Lake Avenue. He said the right things about patience and security and the importance of not making large decisions quickly. Virginia had found him credible and had called his office the following week. The arrangement began properly. Solis reviewed Thomas's investment accounts, recommended a consolidation into a unified managed portfolio, and charged a standard advisory fee. He was responsive. He called when the market moved significantly. He sent quarterly statements that Virginia read without having the technical framework to evaluate their accuracy, which Solis had assessed and relied upon. In 2018, he suggested that managing the Glendale rental properties through an LLC would provide tax and liability benefits, and Virginia agreed, signing the formation documents at his office. She did not ask for independent counsel. She did not tell her attorney. She had one, an estate lawyer in Arcadia named Roberta Lim, who had handled Thomas's probate, because Solis had said it was a standard structure, and Virginia had believed him. The LLC was the first instrument of transfer. Solis had himself named as co-manager of the entity, a designation Virginia had initialed on page 7 of a 40-page document that she had not read fully and would not have understood fully if she had. Over the following 18 months, using the LLC Management Authority, Solis transferred both Glendale rental properties into a second LLC, of which he was the sole member. The transfers were recorded with the Los Angeles County Recorder's Office in 2019. Virginia did not receive notice. The transfer documents had been sent to Solis's office address, which he had listed as the LLC's registered address. In 2019 and 2020, using a durable power of attorney Virginia had signed in 2018, presented to her as a routine document for managing her investments in her absence, Solis liquidated the investment portfolio in increments and transferred the proceeds to accounts he controlled. His wife, a woman named Sandra, had co-signed the account applications for the receiving accounts, listing a residential address in Burbank. The transfers were structured to avoid automatic bank reporting. No single transaction exceeded $9,500. There were 247 of them, over 31 months. By October of 2021, the account into which Virginia's pension was deposited held $312. The investment accounts were empty. Both Glendale properties were titled to Solis's LLC. The Cordova Street house remained in Virginia's name. Solis had not yet moved on it, which investigators would later attribute to the relative complexity of transferring a primary residence without the owner's awareness. The pension check bounced, and Virginia stood at the kitchen counter, and then she went to the bedroom. She had not lifted the floorboards since Thomas put the safe there in 1987. She had not needed to, but she remembered exactly where the loose section was. 3 planks in from the east wall, the second board in the run, the one that had always had a slight give underfoot, that Thomas had said was intentional. She found the edge with a flathead screwdriver and lifted the panel, and there it was. In the crawl space below, a gray metal box bolted to the joist with 2 lag screws, combination lock on the face, a fine layer of dust on the top that had accumulated across 34 years of being exactly where Thomas had put it. The combination was the year they bought the house, 1979. The crawl space beneath the bedroom floor was 18 inches deep and smelled of old wood and mineral earth and the particular stillness of a space that has not been disturbed in decades. Virginia lay flat on the bedroom floor with her upper body through the access panel and used her phone's flashlight to see. The safe was there, bolted as Thomas had said, the gray paint intact, the combination dial stiff but functional. She entered the combination twice before she felt the resistance give and the bolts retract. She could not open the door fully from her position. She unbolted it from the joists. Thomas had designed it to be removable. There were only 2 lag screws, and he had left the correct bit taped to the inside of the panel and lifted it up through the opening and onto the bedroom floor. It weighed perhaps 20 pounds. She sat on the edge of the bed with it on her lap and opened the lid. Thomas had packed the safe with the deliberate thoroughness of a man who understood load-bearing structures and applied the same thinking to information. The contents were in labeled Ziploc bags, each pressed flat to maximize space. The first bag held the original deeds to both Glendale rental properties, recorded copies with the Los Angeles County Recorder's stamps, showing Virginia and Thomas Hale as joint tenants. The second held the Cordova Street deed, the mortgage satisfaction letter from 1997, and the title insurance policy from their original purchase. The third held their tax returns from 2010 through 2016, the last full year Thomas had filed. The fourth held 12 months of investment account statements from 2016, the year before Thomas died, showing the portfolio's composition, account numbers, and a total balance of $1,387,000. The fifth bag held a single document that Virginia did not recognize, a letter from Thomas to a Los Angeles County Deputy Public Guardian, dated January 2017, 1 month before he died. Thomas had written, "I am in declining health. My wife Virginia will be alone after I'm gone and does not have experience managing our finances. I am writing to place on record that she is the sole beneficiary and owner of all assets described in the attached inventory. If any transfer of title or account ownership occurs after my death without her written consent, verified by independent counsel, I am asking that this letter be treated as evidence of my intent and her rightful ownership. The letter had been sent by certified mail. The return receipt signed by the Deputy Guardian's office was paperclipped to the back. The sixth bag held a handwritten note from Thomas to Virginia. 2 paragraphs, undated but written in the same period as the letter based on the handwriting. Slower, more deliberate than his usual hand. The first paragraph told her where everything was. The second paragraph said, "If someone has been managing the money and something has gone wrong, take the 2016 statements and the deeds to Roberta Lim. She knows what they should look like. Tell her to compare them to whatever exists now." Virginia read the note twice, sitting on the edge of the bed in the October afternoon light. Then, she called Roberta Lim's office and said she needed an appointment as soon as possible. The receptionist said Thursday. Virginia said she needed Tuesday. The receptionist said she would check. Roberta called back within the hour and said Tuesday at 9. Virginia spent the rest of Monday going through every paper document in the house, the file cabinet in the home office, the accordion folder in the kitchen drawer, the shoebox of financial papers she had not organized since Thomas died. She found the LLC formation documents. She found the power of attorney. She found, in a manila envelope she had not opened, a letter from the Los Angeles County Recorder's Office, dated March 2019, notifying her of a recorded deed transfer for one of the Glendale properties. She had received it. She had not understood what it meant. She had filed it without responding. She put everything in a paper bag, added the contents of the safe, and set it by the front door for Tuesday morning. Then, she went to the kitchen and made dinner, because it was dinner time, and because there was nothing more she could do that evening, and because Thomas had taught her that preparation and panic were not the same thing and only one of them was useful. Roberta Lim had been practicing estate and property law in Arcadia for 27 years, and she had handled Thomas Hale's probate in 2017 with the same methodical competence she brought to everything. When Virginia spread the contents of the paper bag across Roberta's conference table, on a Tuesday morning in October, Roberta did not speak for the first several minutes. She read the 2016 statements. She read the LLC formation documents. She read the power of attorney. She found the page with the co-manager designation Virginia had initialed. She found the clause granting transfer authority. She set that document down and said, "Virginia, I need to make a phone call before we continue." Virginia said, "Make it." Roberta called a colleague, a civil litigation attorney named Stephen Park, who practiced financial elder abuse law from an office in Glendale, and whom Roberta had referred cases to twice before. Park came to Roberta's office that afternoon. He reviewed the documents for 90 minutes, and then outlined the legal position in terms Virginia could follow precisely. The applicable California statute was Welfare and Institutions Code, Section 15,610.30, which defines financial elder abuse as the taking of property from a person over 65 through undue influence, fraud, or breach of a fiduciary duty. An investment advisor who holds a power of attorney for a client occupies a fiduciary position. They are legally required to act in the client's interest and are prohibited from self-dealing, meaning they cannot transfer the client's assets to themselves or to entities they control. Every transfer Solis had made using Virginia's power of attorney had violated this duty. The LLC transfers of the Glendale properties, recorded in 2019, were executed under the same fiduciary authority and were equally void as self-dealing transactions. The 247 investment account transfers were individually documentable through bank records that Park immediately subpoenaed. Thomas's letter to the Los Angeles County Deputy Public Guardian, the certified letter from January 2017, was the piece Park found most significant. It was a contemporaneous declaration by the property owner, sent to a government office and signed for, stating his intent regarding Virginia's ownership and flagging the specific concern that transfers might occur without proper independent verification. It was not legally binding in a contractual sense. but it was admissible as evidence of Thomas's intent and, more importantly, it demonstrated a documented record that predated Solis's entire tenure and directly contradicted any claim that the transfers had been made with the family's knowledge and approval. Park filed a civil complaint in Los Angeles County Superior Court in November of 2021, naming David Solis and Sandra Solis as defendants and alleging elder financial abuse, breach of fiduciary duty, fraud, and conversion. He simultaneously filed a complaint with the California Department of Financial Protection and Innovation, which oversees registered investment advisors, and provided the transaction documentation to the Los Angeles County District Attorney's Financial Crimes Unit. The DFPI suspended Solis's investment advisor registration within 30 days of the complaint. His office on Lake Avenue closed the following week. The confrontation came at a preliminary hearing in February of 2022. Solis's attorney, a defense litigator from a Century City firm, argued that the LLC transfers had been made with Virginia's knowledge and consent, that the power of attorney was a valid instrument she had signed freely, and that the investment liquidations represented portfolio management decisions within the scope of his authority. Park stood and presented the bank records showing 247 sub-threshold transfers to accounts in Solis's and Sandra's names. The LLC operating agreement showing Solis had transferred the Glendale properties to his sole member, LLC, using Virginia's co-manager signature block on documents she had not seen, and Thomas's 2017 letter to the Deputy Public Guardian. He said an advisor who structures 247 transfers to stay below federal reporting thresholds is not exercising discretionary portfolio management. He said the court was looking at a 4-year systematic theft from a 76-year-old widow, documented in the defendant's own transaction records. Solis's attorney requested a continuance. Judge Sandra Wu granted 2 weeks. 3 weeks later, the DA's Financial Crimes Unit arrested David Solis and Sandra Solis at their Burbank home. The charges included elder financial abuse under Welfare and Institutions Code, Section 15,656, grand theft in the first degree, money laundering, and filing false instruments with the county recorder. Sandra was charged separately for her role in co-signing the receiving accounts and the LLC transfer documents. The search of their Burbank property recovered $340,000 in a home safe, financial records documenting the full transfer history, and, in a filing cabinet in the home office, a folder labeled with Virginia's name containing copies of documents Virginia had never seen, LLC amendments, account closure forms, a draft deed transfer for the Cordova Street property that had not yet been filed. The Cordova Street transfer had been prepared. It had not been executed. Solis had been 2 steps from completing the full acquisition of Virginia's estate when the pension check bounced. The civil judgment was entered in September of 2022. The court found both defendants liable for $2.2 million in compensatory damages and ordered an additional $660,000 in treble damages under California's elder abuse statute, which permits damages of up to 3 times the actual loss when the abuse is found to have been willful and premeditated. The Glendale properties were restored to Virginia's title through a court-ordered corrective deed recorded with the Los Angeles County Recorder in October of 2022. David Solis was convicted in criminal proceedings in March of 2023 and sentenced to 9 years in state prison. Sandra Solis received a sentence of 4 years. Asset recovery, conducted through the civil judgment and criminal restitution order, totaled $1.87 million over 18 months. The $340,000 from the home safe, the equity in the Burbank property, liquidated investment accounts held in Sandra's name, and structured restitution payments. The Glendale rental properties, once retitled, resumed generating rental income immediately. Virginia did not attend either sentencing. She was in Pasadena both days, and on the day of David Solis's sentencing, she was in the backyard, which needed attention after 2 years of her focus being directed elsewhere. The final asset recovery payment was confirmed on April 3, 2024, bringing the total to $1.87 million against the $2.2 million loss, a recovery rate that Stephen Park told her was among the highest he had seen in a case of this scale, attributable in significant part to the quality of the documentation Thomas had left in the safe. Virginia said she would tell him. Park looked at her for a moment and then said, "Yes, I suppose you can." She had not sold the Cordova Street house. She had considered it. The house was large for one person and the maintenance was real. But she had decided to stay, at least for another year, at least until the decisions that had been made in crisis could be reviewed in calm. She had the bedroom floors properly refinished in the spring of 2023, the loose section fixed and sealed, the safe relocated to a closet shelf, where it did not require lying on the floor to access. She kept the same combination. There was no reason to change it. The Glendale rental properties were professionally managed now, through a property management firm Roberta had recommended, with quarterly statements that Virginia reviewed with Stephen Park's paralegal once a season. The investment accounts had been reconstituted through a fee-only fiduciary advisor, a woman named Grace Chu, recommended by the California Department of Financial Protection and Innovation's Consumer Resources List, whose fee structure was flat and whose conflict of interest disclosures Virginia had read completely before signing anything. Virginia had also retained Roberta to review every financial document before she signed it. This was not paranoia. It was a system, and Thomas had taught her that systems were what held when judgment was tired or trust was misplaced. In the fall of 2023, Virginia contacted Bet Sedek Legal Services in Los Angeles, which provided free civil legal assistance to elderly residents and had a dedicated elder financial abuse unit. She made a donation and spent an afternoon with their supervising attorney, describing the specific sequence of decisions she had made between 2017 and 2021. The seminar, the LLC formation documents she had not read, the power of attorney she had signed without independent review, the county recorder notice she had filed without understanding. She described these not as failures of intelligence, but as failures of structure. She had not had a system for evaluating financial documents. She had not had an independent relationship with an attorney during those years. And she had not known that a fiduciary advisor was legally prohibited from transferring client assets to himself. The attorney said those three gaps appeared in nearly every elder financial abuse case they handled. Virginia said, "Then those are the three things to teach." The lemon tree in the back corner produced well that July, as it always had. Virginia filled paper bags and wrote her name on the sides and distributed them to the neighbors, as she always had. The neighbor 2 doors down, a woman named Carol, who had moved in during the pandemic, came to the door herself to say thank you, and they stood on the porch for 20 minutes, talking about nothing consequential, and Virginia found she did not want the conversation to end, which was not always how she felt about conversations, and which she took as a sign that something had returned to its correct position. Thomas's note from the safe, the 2-paragraph handwritten note, undated, slower handwriting than usual, was in a frame on the bedroom dresser. She had put it there after the floors were refinished, when the safe moved to the closet, and the note no longer needed to be stored inside it. She read it sometimes in the morning before she was fully awake, the way you read something you know but want to hear again. He had known something was possible, had prepared for it without telling her he was preparing, had left the preparation exactly where she could find it when she needed it, and not before. She thought that was, in its way, the most precise thing he had ever done for her.